I appear as the living man, John of the family Smith, administrator for the private estate known as John Doe Smith. I do not consent to these proceedings, and I challenge your jurisdiction over this vessel. What if you could just talk your way out of any legal or financial trouble? What if a few magic words in a binder full of weird documents could make $35,000 in debt just disappear? This was the exact promise a man, calling himself a secured party creditor, sold to a vulnerable retiree. He wasn't just offering advice. He was peddling a secret key to a legal system that he claimed only a chosen few could understand. He genuinely believed he was untouchable, but his fantasy was about to smash headfirst into reality. A reality in the form of a judge who had seen this all before. A judge who had no time for scripts, affidavits, or declarations of made-up sovereignty. A judge who was about to patiently, methodically, and completely dismantle this entire house of cards with one simple, devastating question. This is the story of how a sovereign citizen's elaborate estate scam got exposed and shut down, revealing the huge gap between fictional legal theories and the unyielding power of the actual law. Stick around because you're about to see the precise moment his arrogance completely shatters in court. So, before we step into that courtroom, let's break down the architecture of the trap that was laid. This wasn't a simple misunderstanding. It was a carefully marketed package of bad information, sold for a shocking price. The defendant in our story, a Mr. John Smith, was no lawyer. He was a self-proclaimed legal guru, a graduate of the University of Online Forums and seminars that push a belief system known as the sovereign citizen movement. At the very heart of this movement is one core and totally flawed belief, that the government is an illegitimate corporation. They think that when you're born, the government secretly creates a trust or a corporate shell, the strawman, using your name in all capital letters. The whole goal for a sovereign citizen is to separate themselves, the living man of flesh and blood, from this corporate fiction. And if they do that, they believe they become immune to the laws, taxes, and debts of that corporate government. Mr. Smith took this ideology and turned it into a product. His target was a retiree we'll call Mr. Johnson, who was drowning in debt and desperate for a lifeline. Smith offered him what sounded like a miracle, a $35,000 estate trust administrative process package. In an email, he guaranteed him, that's the key word, that this package would completely wipe out all of Mr. Johnson's debts within 90 days. For someone crushed by financial anxiety, this sounded like salvation. So what did Mr. Johnson actually get for his $35,000? Not a team of lawyers, not a negotiated settlement. He got a binder, a thick binder, filled with the usual templates from the sovereign citizen playbook. Things like a private trust indenture, where Mr. Johnson was supposed to make himself the executor of his own private estate to separate himself from his debts. It also had an affidavit of truth, a document he wrote himself declaring his sovereignty and renouncing his citizenship. Most importantly, it came with instructions on how to file a UCC-1 financing statement. Now, in the real world, a UCC-1 is a boring, standard form. It's just a notice a creditor files to claim a debtor's property as collateral. It's a tool for lenders. But in the sovereign citizen universe, it's twisted into a weapon. They believe that by filing a UCC-1 against their own strawman name, they somehow become the main creditor over themselves. This lets them use a bizarre process they call acceptance for value, or A for V, where they think they can just accept a bill, send it to the US Treasury, and the Treasury will pay the debt from a secret account tied to their birth certificate. This is the fantasy Mr. Smith sold. A fantasy of secret government accounts and legal immunity. Mr. Johnson, trusting the guarantee, wired him the $35,000. He followed the instructions to the letter. He sent the strange, demanding letters, and for 90 days, he waited for the magic to happen. It never did. His creditors ignored the bizarre notices, and his financial situation got worse. The $35,000 was gone. The relief never came. Realizing he'd been sold a lie, Mr. Johnson did the one thing sovereign ideology says you never have to do. He hired a real lawyer and took Mr. Smith to a real court. The quiet, formal atmosphere of a courtroom is a long way from the echo chamber of an online seminar. Here, words have very specific meanings, and authority comes from laws and constitutions, not from homemade affidavits. The clerk's voice cuts the silence. Calling case number 2 for CV 5678, Plaintiff Johnson versus Defendant Smith. The plaintiff's lawyer, a woman in a simple business suit, stands up. Your Honor, counsel appears for the plaintiff, Mr. Johnson. She's calm, professional, ready to argue facts. Then, it's the defendant's turn, Mr. Smith reases. But not like a normal defendant, he's here to put on a show. He puffs out his chest and launches into the script he's clearly rehearsed. I am here by special appearance. I am the living man, John of the family Smiths, administrator for the private estate known as John Doe Smith. I do not consent to these proceedings, and I challenge your jurisdiction over this vessel. A look of pure weariness flashes across the judge's face. This isn't his first rodeo. He leans forward, his voice calm but firm, making it clear who's in charge. Sir, your appearance is noted. This court will not be debating pseudo-legal theories today. Any more disruptions or attempts to lecture the court on your personal beliefs will result in sanctions. Do you understand? Smith, thrown off balance by the judge's immediate control, tries to recover. I do not consent. This is a common law court, and you haven't proven your jurisdiction. Show me the wet ink contract where I agree to be a party to this action. This is a classic sovereign tactic. They believe the court's authority over a person has to come from explicit, written consent for every single interaction. The judge, however, isn't playing this game. He looks at Smith, but he's really speaking for the record. Mr. Smith, let me be perfectly clear. This court's authority to hear this case comes from the laws of this state. It doesn't come from your consent. This court's jurisdiction over you was established when you were properly served notice of this lawsuit, and it's further cemented by your physical presence here today. Whether you call your appearance special or not is irrelevant. You are here. Your consent is not required. We will now proceed with opening statements. The judge's response is a masterclass in shutting this down. He doesn't get into a debate about common law versus admiralty law. He doesn't engage with the living man nonsense. He cuts right to the bedrock of the legal system. Jurisdiction comes from law and proper notice. With that one clean explanation, he has completely dismantled the defendant's opening move. The sovereign's first shield has been shattered, and the trial has barely begun. The plaintiff's lawyer steps forward. Her opening statement is a straightforward story of exploitation. Your Honor, the evidence will show that the defendant, Mr. Smith, ran a scheme preying on someone in financial distress. He promised a guaranteed result, the total discharge of all debts in 90 days. He took $35,000 from my client for that promise. What he delivered wasn't a legal service. It was a binder of useless documents based on a debunked fantasy. The evidence will show a clear case of fraud and breach of contract. We will ask for full restitution and an order stopping Mr. Smith from ever running this scam again. The first witness is the victim, Mr. Johnson. He looks exhausted. He recounts his initial desperation and the hope Mr. Smith's sales pitch gave him. His lawyer guides him. Mr. Johnson, I'm showing you Exhibit A. Do you recognize it? Yes, he says quietly. That's the invoice from Mr. Smith for his estate trust process, for $35,000. And what is Exhibit B? That's the email he sent me. The one where he guaranteed all my debts would be discharged in 90 days. The word guaranteed hangs in the air. The lawyer moves on, presenting Exhibit C, bank statements showing the 2 wire transfers to Mr. Smith. Each document is another brick in the wall of evidence. Mr. Johnson, the lawyer asks, her voice gentle, after you paid the $35,000 and followed Mr. Smith's instructions, were any of your debts actually discharged? No, Johnson says, shaking his head. Not one. I just started getting more default notices. The banks just ignored the papers I sent. One of them actually called me and asked if it was some kind of a joke. Next, another witness, who had also been sold a smaller package by Smith, confirms the same method. The lawyer shows them Exhibit E, a notice of default Smith had told them to send to a credit card company. What happened after you sent this? Nothing, the witness says. Absolutely nothing. It's just paper, it has no power. When it's Smith's turn to cross-examine, his arrogance is back. Representing himself, he sees this as his chance to shine. He approaches Mr. Johnson. You entered into a contract with me, did you not? A binding agreement? Johnson starts, but his lawyer is already on her feet. Objection, Your Honor. Calls for a legal conclusion. Sustained, the judge replies, his patience clearly wearing thin. Mr. Smith, ask about facts. You will not ask witnesses to interpret the law. Smith tries again with a second witness. My affidavit of truth, which I sent to you, stands unrebutted, correct? You failed to rebut it point by point. The witness just looks confused. I don't know what that means. I just know the bank ignored it. The judge interjects again. For the record, a private self-authored affidavit has no legal force or effect on a third party without their agreement. The failure to rebut such a document is legally meaningless. Proceed, Mr. Smith, but I suggest you move on to relevant facts. But Smith has no relevant facts. His entire case is built on the supposed magic of these documents. With his core arguments already shot down by the judge, his cross-examination just fizzles out. The plaintiff's counsel stands. Your Honor, the plaintiff rests. The case is simple and brutal. A lot of money was paid for a guaranteed service that was never delivered. Now, it's all on John Smith. This is his moment to prove his system works. He starts presenting his evidence, the contents of the binder he sold. I present to the court Exhibit D, he announces with a flourish. This is my UCC-1 financing statement. It perfects my claim as the secured party creditor over the John Doe Smith estate. This court is secondary to my claim. He holds up another document. Exhibit F, my affidavit of truth. In it, I declare my sovereignty. This was served on the plaintiff and stands unrebutted, making it the law of this case. Finally, the supposed masterpiece, the plaintiff's and Exhibit G, the private trust indenture, which creates the private estate and separates the man from the fictional name. The debts belong to the defunct trust, which I, as the creditor, choose to settle. He stands back, acting like he just dropped a bombshell. To anyone unfamiliar with this stuff, it's a dizzying waterfall of legal-sounding jargon: perfected claim, secured party, unrebutted affidavit. It's designed to sound impressive and confusing, but the judge is not an untrained ear. Okay, so what did he really just say? Let's break it down. He claims filing a UCC-1 makes him the boss of his own debt, but a person can't just file a notice against themselves to cancel out all their other debts. That's not how it works. He then claims his affidavit of truth is law because nobody argued with it. That's like mailing a letter that says, "I'm the King of England," and then claiming it must be true because the mailman didn't correct you. It's meaningless. Finally, his private trust is just a document he wrote himself. It has no power to make legal debts disappear. He's built a complete fantasy on a foundation of misinterpreted rules and wishful thinking. Back in the courtroom, the judge looks down at the pile of documents. He doesn't look impressed. He's patiently listened to Smith's entire theory. He let him build his own scaffold. And now, he's ready to pull the lever. The judge pushes the stack of exhibits aside. He doesn't need to read the fine print. He knows Smith's entire defense rests on a single, fatal flaw. He leans into his microphone, his eyes locked on the defendant. "Mr. Smith," the judge begins, his voice perfectly even. "I've listened to your arguments about UCC filings, your status as a living man, and your private trust. I'm going to set all of that aside for one moment and ask you a very simple question." He pauses, letting the silence hang in the air, pulling all the focus in the room right onto Smith. "In all of this," the judge continues, "can you please point to a single document, just one, that shows a creditor, a bank, a credit card company, anyone Mr. Johnson actually owed money to, agreeing to this arrangement? Can you show me one signed piece of paper from a creditor? Or can you show me an order from any court that legally extinguished one of Mr. Johnson's debts?" That's the question. The one question that cuts through all the jargon and all the fantasy. It bypasses the entire pseudo-legal script and hits the core of how debt actually works. Debts are obligations. You can pay them, you can settle them by agreement with the creditor, or you can discharge them in a formal proceeding like bankruptcy. You can't just wave them away with a document you printed at home. Smith looks visibly stunned. The question completely sidestepped his script. He was ready for a fight over jurisdiction, the definition of a person, or the flag in the courtroom. He was not ready for this simple demand for proof. He stammers. The acceptance for value process settles it through the Treasury. It's a public remedy. The judge is unmoved. "That's not what I asked, Mr. Smith. I asked for proof. I asked for a creditor's signature or a court order. Do you have either of those? My unrebutted affidavit?" Smith starts again, falling back on his failing script. "It's not a court order." The judge cuts him off, his voice hardening. "It is a piece of paper you wrote. Do you have a consent form from a bank? Do you have a judgment from a judge, yes or no? The UCC filing ... does not discharge debt," the judge states, his voice now ringing with authority. "It's a notice of billboard. It doesn't create rights against people who don't agree to it. The expert from the state filing office already testified to that. So, I will ask you one last time, Mr. Smith, can you provide this court with a single piece of evidence showing that a creditor or another court agreed to discharge these debts? Yes or no?" Silence. John Smith is just standing there. His binder of documents suddenly looks exactly like what it is, a pile of worthless paper. The arrogance is completely drained from his face, replaced by raw panic. He has no answer. His entire fantasy, his $35,000 product, his whole identity as a legal guru, it's all been unraveled by a question so simple he had no defense against it. "No," he finally mutters, the word barely audible. "I do not. The house of cards has collapsed." The closing arguments are a formality. The plaintiff's counsel briefly recaps the facts. Money was paid, a guarantee was made, and the guarantee was broken. When it's his turn, Mr. Smith just repeats, "Sovereignty and unrebutted affidavit," a hollow echo of his earlier confidence. The judge just waves it away. Argument previously noted and rejected. Then, the judge delivers his verdict, and it is a complete humiliation. The court makes the following findings of fact. He begins. 1. The plaintiff, Mr. Johnson, paid the defendant, Mr. Smith, $35,000, proven by Exhibits A and C. 2. The defendant gave a written guarantee of debt discharge within 90 days, proven by Exhibit B3. This promise was not fulfilled. No debts were discharged, a fact confirmed by the plaintiff and not disproven by any credible evidence. He goes on. The court finds that the defendant's legal process involves filing non-binding private notices and a frivolous UCC-1 financing statement. The court finds, based on expert testimony and established law, that these documents have no power to force a creditor to do anything or to discharge debts. The defendant's entire defense is based on pseudo-legal theories that have been rejected by every state and federal court in this country. This court has proper jurisdiction. The defendant's claims of being a sovereign are legally irrelevant. Private affidavits have no legal effect. A UCC-1 filed by a debtor against themselves is meaningless. Therefore, the court finds for the plaintiff on the grounds of fraud and breach of contract. The final order is swift. It is hereby ordered that the defendant, John Smith, shall pay the plaintiff, Mr. Johnson, restitution in the full amount of $35,000 plus court costs. It is further ordered that Mr. Smith is permanently banned from selling any more debts, elimination, or sovereign citizen packages. The defendant is warned that filing any more frivolous documents will result in sanctions.